Establishing the legality of fishing licenses. Issues. Otis Lillycarp is a scallop fisherman in New South Wales. Stocks of scallops are dwindling, and so the state parliament has enacted legislation that provides that each person wishing to fish for scallops must obtain an annual license, may be granted one license only, and is limited to taking 50 scallops from the sea per month. Otis has incorporated 3 companies: Otis Fishing Proprietary Limited Company, South Coast Scallops Proprietary Limited Company, and Lillycarp Fishing Proprietary Limited Company, and as managing director of each applies for 3 licenses, as well as a license for himself. The legal issues that pertain to this case scenario are pretty straightforward as it regards the determination of legality of Lillycarp's fishing licenses and the way that they were obtained. This in general is the only issue that would need to be determined. But several other issues are related to this case and must be considered as well. 1. The specifics of this law that regulates the fishing of scallops are bound to be under scrutiny in the determination of this fact, but because the details of the laws have not been elaborated, it means we shall have to make a lot of assumptions. Finally, there are issues to do with the separation of businesses from their owners since they are separate entities, which we shall have to address as we interpret this particular law. Application. Foremost, let us set out and establish the position of the law as relates to the 3 limited companies in which Lillycarp is the managing director, and therefore lay the basis for the determination of the legality of the 4 licenses that have been applied by Otis. According to business law, the incorporation of a company has 2 legal effects. Firstly, it creates a legal person, and secondly, that legal person has perpetual succession. Based on this fact of law, it would then appear that Otis does indeed have 3 companies that are separate legal entities that are completely different from him. In fact, the law explicitly states that a company is recognized as a person in law, and in addition to this holds that the owner of the company is quite different from the company itself, and the only difference between a company and a real person is that the company is an artificial person, so to speak. These facts of laws have great implications to the determination of the issues at hand. 1. The fact that Lillycarp's companies are persons, albeit artificial ones, implies that they can function as real persons and thereby apply for fishing licenses just as any person would do. Besides, the separation of the company from its owner, usually referred to as the veil of incorporation, is an important distinction in this case. This is because it would mean that Otis is following the law, since the applications of the other 3 do not mean that he is the actual person who is benefiting from the proceeds of the fishing, but rather the separate business entities. So far, if we had the specifics of this law, we would have been able to refer to it and determine if any exceptions are described in any sections of the law. But despite what the details of this specific law might have been, there are 2 other relevant facts of law to note as far as incorporation of companies is concerned. One is that the law, as a matter of fact, is very reluctant in enjoining the owners of a company with their companies unless under exceptional circumstances. This is the reason that the courts usually do not look behind the veil to inquire why the company was formed or who really controls it. Secondly, the law does allow for companies to own property distinct from the property of its members or owners. So, what would all this mean to our case that is at hand? Several things. 1. That the New South Wales Fisheries Department has no business knowing the actual owners of the company, and this fact should be considered irrelevant in the determination of whether Otis is acting illegally in applying for 3 other licenses using his companies as fronts. In fact, as far as New South Wales Fisheries Department is concerned, Otis has only applied for 1 license only because the others have been instituted by completely different entities. Secondly, it would also mean that New South Wales Fisheries Department would have no basis for prosecuting Otis for multiple applications for licenses until they obtained recourse to lift the veil of incorporation that ideally exists for these companies, and that is unlikely to happen without good reason. This is especially the case since the existence of Otis as a person has no significance to the issue at hand, since the 3 companies might very well continue applying for licenses even if Otis was to cease existence, which is our third point. Finally, as a lawyer for the New South Wales Fisheries Department, Otis has complied with the law since there is only 1 license that has been applied under his name, and if companies are not entitled to this particular license, then the companies are to sue but not Otis.